Muchas gracias. Bueno, pues hoy tendremos la segunda sesión con el doctor Malcolm Coulthard y además, lamentablemente, la última, esperando que regrese pronto.
Thank you very much. I'm glad it's the last one because I'm getting tired. You'll all be delighted to know that I've signed the certificados, so you can leave now if you want, but I'll try and talk from here for at least some of the time because I feel a long way away from you if I'm sitting there, and it's much more difficult to interact. To begin with, I thought I'd just like to mention 3 publications that might be interesting for those of you who want to follow up some of the things that I've done. The first is an introductory book that I wrote with an ex-student and now close friend, Alison Johnson, in 2007. I think some or all of you have already had a copy of one of the chapters, illegally of course. In England, this is now massively controlled, and if universities make copies, they have to pay to the publisher for each page that they have actually copied. In Brazil, it's interesting, the copyright law gives different protection to the author, and in fact it allows all students to make one copy of everything without having to pay anything. So provided you're making the copy for your own use, there is no copyright control in Brazil. In Britain there is, and you can only copy 10% of a book before you have to start paying. So interesting to see the differences in the copyright laws. I'd be interested to know, somebody tell me afterwards what the laws are, or if there are laws here in Mexico for students. So that's an introductory book that we produced. It's now aging and we're thinking about producing a new edition, but at the moment there are a whole series of books, but I still think this one probably covers more of the area and slightly better. For those who want to go further, we produced a handbook in 2011. This is a collection of 40 chapters covering the whole of the area of forensic linguistics or language and the law. There are articles by lawyers, there are articles by sociologists, by linguists, by phoneticians, and there's also one by an Australian judge who became interested in forensic linguistics. He joined our association and he became a member of the committee, and he wrote a final chapter for us reflecting on what forensic linguistics could offer the legal system. Last year, I founded, along with an ex-student, a new journal called Language and Law and Linguagem e Direito, because being based in Brazil, one of the things that is lacking for my students is material in Portuguese. So we've now got a bilingual journal which publishes in English and Portuguese, and we are beginning to create a resource particularly for the Brazilian students, but I'm sure it's the same for many of you here. There is actually more prestige in Brazil if you publish in English, so many of the Brazilians actually want to publish in English. And in this first issue, there's an article by a public prosecutor, a Brazilian public prosecutor, which links to what I was talking about yesterday. One of the things I was saying is, if you have non-native speakers, somebody has to decide if they need an interpreter. And in Brazil, it's still the judges. As I say, in Britain and Australia, it's been taken out of the hand of the judges, and if anybody is a non-native speaker, the court insists that they have an interpreter. In Brazil, as it used to be in Australia, it's the judge who decides. And many of the public prosecutors are unhappy with this because they feel that the indigenous people don't have sufficient command of Portuguese to be tried in Portuguese, that they need to have interpreters. And the judges obviously don't want that because it slows down the process. So there's a struggle between the judiciary and the lawyers. And in the article he wrote for us, he reports a famous case in São Paulo, where the prosecutors said they wanted interpreters and the judges refused to allow interpreters. So first of all, the lawyers refused to go into court, and for a month there was a standoff between the judges and the lawyers. Eventually the judges insisted that the case was tried, but the lawyers advised the clients simply not to speak. And so it became impossible for the trial to proceed because the judges insisted on speaking Portuguese, and the witnesses and the accused refused to speak in Portuguese. And eventually the case was abandoned. But the prosecutor says there is a hidden agenda which I wasn't aware of. The indigenous people in Brazil have land rights, and these land rights are protected just as the land rights for the Aboriginals in Australia are protected. But apparently, in order to qualify in Brazil for land rights, you have to be unable to speak Portuguese. So if you start speaking Portuguese, you become an ordinary Brazilian and you lose your land rights. So there is this pressure to make more and more people speak Portuguese because they have fewer and fewer land rights, and therefore you can have more and more exploitation of the Amazon rainforest to the disadvantage of all of us, because all these potential new medicines are being burnt on a daily basis. So this journal, the first issue, I think is a very nice issue. In fact, it's too big. It has 12 articles in it, and I've discovered that that was a mistake. But it's got a very nice collection of articles, and it's totally free access. So you can find it with Google, and you can access it, and you can read or download any or all of the articles. The next issue is in press now, and the next issue is going to be exclusively about forensic phonetics. There will be 3 articles in English, 3 in Portuguese, and one of the articles I mentioned yesterday is by an Australian woman, an Australian forensic phonetician, who has been investigating, as I mentioned yesterday, the linguistic equivalent of the car crash test. Remember, I was saying, if you ask people what speed did the car crash as opposed to what speed did the car hit, they see the car as having been going faster. What she's been doing is finding how can you prejudice people's hearing so that you give them the same bit of language, but they hear different things depending on the linguistic context in which they hear it. So those are 3 publications which I hope will interest some of you. There are now 2 associations which are concerned with language and the law or forensic linguistics. There's the IAFL, which is the International Association of Forensic Linguists. This association is now just over 20 years old. We founded it in the University of Birmingham in 1994, and it now has over 200 members worldwide, and it has international conferences every 2 years. The next one is in July in China, in a city called Guangzhou. The last one was actually here in Mexico City in 2013. I'm not sure exactly where it was based, but it was here in Mexico City. There's a new organization now that we've just formed in Brazil with the acronym ALIDI, the Associação de Linguagem e Direito, so the Association of Language and Law. And that is open to anybody, but I say it's essentially to encourage forensic linguistics within Brazil. And we're hoping that round about Easter next year, we'll run a conference in the very north of Brazil, a place called Natal. And so I hope that we will see some of you there. Maybe March, it may be April next year. That will be an international conference. We ran the first one 2 years ago in Florianopolis, and we had about 140 participants, which I think is ideal. Many of them international. And so the conference mainly ran in English, although there were some things in Portuguese as well. For those of you who don't know anything about Brazil, the names of the cities are quite fun. So that we were originally going to run this conference in December. And so I wrote to people saying, you can come to Natal in December. And Natal is obviously Christmas. And a little bit further round the coast there is Belém, which is Bethlehem. And if you go further down the coast, you get to Salvador. And then if you stay long enough, you can finish up in January in Rio de Janeiro. And you know, the foreigners think these labels are quite fun. And you can leave the country at the bottom in the happy port, Porto Alegre, and finish up in Buenos Aires with beautiful winds. So I hope we see some of you in Natal in Easter next year. And I hope some of you, the moment that the second issue of the journal should be available within a month, hopefully a little bit less. 3 articles on, 3 articles in English on forensic phonetics, 3 articles in Portuguese on forensic phonetics. The next issue will be not themed, but the first issue for 2016 is going to be about translation and interpretation, or translating and interpreting in legal contexts. And that's a special issue that we will be producing round about this time next year. Okay, I want to just spend a little bit more time talking about authorship, picking up from 2 days ago, and then I want to move on to talking about legal texts and the interpreting of legal texts. And finally, I will end today talking about product warnings. On the handout in front of you, you've got a text from a very famous and very important English case. The case dates from the beginning of the 1950s. And as most of the other cases I've talked about, this is also a murder case. The story behind it, and I'll read the text through to you eventually, but the story behind it is one, I think it was a November evening, one November evening, two young men went out to try and rob a shop. So they set out with the intention of breaking into a shop, which was the shop where one of them used to work during the day, and he thought there was some money left. Unfortunately, the owner of the shop was still there, so they decided that they would try and break into somewhere else. They saw a warehouse, a two-story warehouse, and they decided there might be something interesting worth stealing in the warehouse. So they climbed up the drain pipe, that is the pipe that brings rainwater down. They climbed up the drain pipe onto the roof to break in from the top. They were seen by a woman who was putting her daughter to bed. 1951. And so she thought they ought to inform the police that somebody was trying to break into the factory. So she sent her husband out to the street corner where there was a telephone box, as I say, and nobody, mobile phones, nobody even had phones in the house, out to the street corner to phone the police. The police responded very rapidly, and two policemen went up onto the roof and they arrested one of the two young men. Other police managed to get into the building and came up through the inside onto the roof. The younger of the two men then produced a gun and started firing shots. As one of the policemen came out onto the roof, he was hit right in the middle of the forehead and died. At this point, the police and the younger of the two men continued firing until his gun jammed, and then he threw himself off the roof, wasn't killed, but was badly damaged, and went to hospital. The one who was arrested, whose name is Derek Bentley, was taken to the police station, and he produced, or the police produced with him, a statement, which is the text you've got in front of you. At a later stage, there was a disagreement about the nature of this statement. The police, as with the case I talked about on Tuesday, said, we asked him to tell us what happened, and he did, and we wrote it down by hand, and then we typed it up. What the supposed author of the statement said was, no, that wasn't what happened at all. Some of it I said, some of it was them asking me questions and me producing answers, and some of it was simply written by the police officers themselves. So in Bakhtinian terms, he says there are several voices in this text. Some of it's me, some of it is them, and some of it is us. The court didn't take any interest in that. This was one of the most rapid murder trials in English history. It lasted only a day and a half, at the end of which this man Derek Bentley was found guilty of murder and sentenced to death. There was an appeal which took about an hour, and it was rejected, and 2 months after being sentenced, he was hanged. Now, I want to go over this linguistically in a while, but in terms of the judicial system, this was an incredibly important case because there was public anger at this. They felt that he shouldn't have been hanged, and this led to a campaign which a few years later led to the abolition of capital punishment in England. So this actual execution saved many, many lives in the future. But this was a decision in 1951, an execution in 1952, and the family continued appealing, asking for a posthumous declaration that he shouldn't have been convicted of the murder. I got involved in this case after about almost 40 years, and I eventually wrote a report which was partially involved in an eventual declaration 45 years later that he shouldn't have been convicted. So in 1996 we got the conviction of 1951 actually overturned. So it took 45 years to manage this miscarriage of justice to rectify it. Now, what I wanted to do now is to go through the text with you and show you some of the linguistic evidence that I produced to say this is indeed not a monologue statement, but is a text which has at least two voices in it. And I will also pick up some of the evidence that the judge at the original trial misinterpreted, and evidence which led directly to his conviction for murder. So these are linguistic points within the statement that led to the overturning of the decision. Now, I've labelled this register. We've looked at a series of linguistic features. One that we haven't looked at so far is language which varies according to use. So far we've been looking at language which varies according to user. So we've looked at dialect and we've looked at idiolect. But language also varies according to use as well as according to user. So I think I've already mentioned the work by a Leeds PhD student who was looking at an enormous corpus from the United States that came from a company called Enron, which went into bankruptcy, and all the emails from this company are now publicly available. So anybody who wants to do authorship analysis can get access to millions of emails, all of them annotated so you know who produced them, who they were sent to. And this PhD student was able to distinguish linguistically between lawyers and those whose job it was to buy and sell energy on the markets, people called traders. So he could distinguish the register, that is the professional use of lawyers, from the professional use of market traders. Now, one of the things I was looking at here was, is there a police register? In other words, do, or at the time did, British policemen have a particular special form of English? And can I find evidence of police register in this text? Evidence which shouldn't be there, because as I was saying to those who were listening yesterday, the English law at the time said the police must write down what the suspect said in the suspect's own words. So if I can find evidence of police language and police usage here, I can demonstrate one of his claims, which was this was not his text, it was their text, so that there was, some of it may have been by him, but some of the formulations and therefore perhaps some of the content was police rather than suspect. And in fact, I hope to show you there's an enormous amount in this text. Firstly, what we'll notice is police officers, when they're writing reports, are highly concerned with time and place. It's important for them when things happened and where they happened. It's often not particularly important for the witness, and these are often the kinds of things that the police officer has to elicit afterwards. So as I said, typically the police officer now in Britain says to the person, tell me your story, and then tries to fill this out by finding out that happened, but when did it happen, where did it happen, etc. Now, one of the things that we'll notice in this text is there's a lot of time and place, highly specific time, highly specific place. And I've distinguished those when I'm going to show it to you using the colours red and blue. So red and blue are used for items of time and items of place. There's also many other features I'm going to talk about. There's also a strange grammatical feature. If you look at the text, one of the things that will jump out at you is a series of black or bold thens. In sentence 8, I then ran out. In sentence 11, I then caught a bus. In sentence 15, Chris then. In sentence 16, Chris then. Now, at the time I was working on this case, the world's first learner's dictionary that was based on a corpus was being written in the University of Birmingham. This became the Collins-Cobild International Learner's Dictionary, a dictionary which revolutionized the way in which dictionaries are written. After that, all dictionaries are now based on corpora. Before that, dictionaries were based on what dictionary makers said about words. Now they are based on corpora. At the time, and this is terribly hard for the young generation here to think, at the time it was terribly difficult to create a corpus. People now, you have MA students with 8 million word corpora. At the time it was very difficult because of particularly another feature that anybody who was born after about 1980 can't really believe, it was exceedingly difficult to scan text. There weren't scanners. And the scanner that we had in the University of Birmingham was the only one in the country. It cost $100,000. An unbelievable investment by the university, which meant it had to work 24 hours a day. So it was rather like the film Metropolis. There were students working 24 hours feeding this machine with text. When I visited the language engineering group yesterday, there was somebody there talking about the problems of scanning in texts in one of the local Mexican languages. I didn't have time to tell her that when this first scanner was used in the University of Birmingham, it would take up to 2 days to teach it a new font. So it would, after 2 days, it would be able to read Times New Roman. If you wanted it to read Arial, that was another 2 days' work so that it could learn. So, you know, you have your printer at home which has a scanner with it, and you put anything into it and it reads it almost perfectly. So in those days, it was unbelievably hard. At the time, the university had a corpus of 8 million words, which was unheard of. You know, before that, the biggest corpus was 1 million words, the Brown corpus, 8 million words of written text. And with great difficulty, there were 2.5 million words of speech. Now, what I noticed here is that there are lots of thens in this text. I've highlighted them for you in black, on bold. Initially, you might think, well, of course, you would expect to find then. This is a narrative. Narratives are about time. Then is a time marker. So, of course, what you'll expect is a text full of thens. But ordinary people, when they're telling stories, don't use then. Police officers use then all the time. Not only that, but when ordinary people do use then, they put it at the beginning of the sentence. Little children will tell you stories and say, then I went to school, and then I had my lessons, and then I had my dinner, and then I went home. Police officers postpose then. So they don't say then I, they say I then. They don't say then Chris, they say Chris then. So, 2 features here. We've got a lot of thens, and we've got thens in the odd position for ordinary people, the obvious position for police officers. So when I looked at this, you've got then virtually every 60 words. When I looked at the co-build corpus, you get then in ordinary speaker writers about every 1,000 words. So the then here is 13 times more frequent than it is in ordinary usage. But surprise, surprise, when I looked at a series of police reports, you get then about every 80 to 90 words. So frequent use of then, because they're interested in time, is a feature of police register. It's not a feature of ordinary use of language. When one looks at the postposing, that is I then instead of then I, this again is a feature of police reports. And I think in this text it occurs about once every 150 words. In the co-build corpus, it was occurring once every 250,000 words. So a very rare feature in ordinary language, a very marked feature in police language. And after this, other pieces of research on police language found the same phenomenon. This post-posing was something that police officers picked up when they learned how to write reports. But as I say, as we go through the text, there are all kinds of police features. So, I've known Craig since I went to school. We were stopped by our parents going out together, but we still continued going out with each other. I mean, we've not gone out together. I'll come back to the underlinings later. I mean, we've not gone out together until tonight. I was watching television tonight, so you see, we now get this repetition. We need the timing. And then 2nd of November 1952, you can't imagine the suspect actually giving the actual date, but it's very important to the police officer. And between 8 p.m. and 9 p.m, so we've now got the exact timing, which is important to the police officer, Craig called me. Another police feature here. The police reports always referred to people by their surname. Ordinary people don't refer to their friends by their surname, but here he's referring to his friend whose name is Chris. He's referring to him by his surname, not his first name. Craig called for me. My mother answered the door and I heard her say that I was out. I had been out earlier, so we've now got more emphasis on time that day. To the pictures, and I got home just after 7 p.m, highly accurate. You know, if you're telling a story of what you did yesterday, I'm sure you won't give me it in this degree of accuracy. A little later, Norman Parsley and Frank Fasey called. I did not answer the door or speak to them. My mother told me they had called and I then ran out. So, you know, you'd say, an ordinary person would say, I ran out, or then I ran out, but not I then ran out. I walked up the road with them. Now we've got place to the paper shop where I saw Craig standing. Again, Craig, surname. We all talked together and then Norman Parsley and Frank Fasey left. Chris Craig and I then caught the bus. We got off at West Croydon and then walked down the road where the toilets are, so we're highly specific, down the road where the toilets are. When we came to the place where you found me, not only is this accurate for time and place, but look at the grammatical complexity. And at this point, I need to tell you that this man whose statement it is a 19-year-old. But he left school at the age of 13. He couldn't read. And his speech was, when his intelligence was assessed, he was in the bottom 1% in terms of intelligence. So we suspect that this is not the kind of grammatical complexity he would handle. We then go down the little iron gate. Chris then jumped up the drain pipe to the roof, more specifically. We both got out onto the flat roof at the top. Then someone in a garden on the opposite side. So we're now getting lots of detail about the geography of the place. Chris said it's a copper, hide behind here. We hid behind a shelter arrangement. Again, not a ordinary low intelligence working class boys language on the roof. A plainclothesman. Now, there's another feature here. The police are very anxious to know which policeman was where. And so, instead of just a policeman, a plainclothesman. So the different kinds of police officers are now highly specified as well. A plainclothesman climbed up the drain pipe and onto the roof. The man said, I'm a police officer, the place is surrounded. He caught hold of me. As we walked away, a little later, went round the corner by the door, from his forehead just above his nose, round the corner behind the brickwork entrance, and so it goes on. We get this highly specific narrative, which is a type of police narrative, not a ordinary person's narrative. And so we can see the interference here. The other thing is that Bentley said, although this is produced as a monologue, it was actually a dialogue which was turned into a monologue. So the police were essentially asking questions. He was saying yes or no, and they were turning their question into what appeared to be his narration. Now that was literally fatal for him, because the evidence that convicted him depended on an interpretation of this statement, assuming it was a monologue. The problem for the prosecution was that they were accusing him of murder, but he was already under arrest when the murder was committed. So he didn't directly commit the murder. He was actually arrested and being restrained by a police officer when the murder was committed. So the question is, how do you convict somebody who didn't shoot and was actually arrested of murdering a police officer? What the prosecution needed to do was, firstly, to show that he knew they had gone out with a weapon. They had to show that the two of them went out with a weapon which they would use if necessary. He said he didn't know. The second thing they had to show was that as he was under arrest, he obviously couldn't commit the crime himself. They had to show that he had incited the other man to shoot. So there were two things they had to show. Firstly, that he knew they had gone out armed. Secondly, that he incited his companion to shoot. In an accompanying police report, one of the police officers said, he shouted, "Let him have it, Chris. Let him have it, Chris." And this was one of the few linguistic points that was debated at the trial. The defence said, "Let him have it" means give him the gun. The prosecution said, "Let him have it" comes straight out of an American Western, meaning shoot him, let him have it. The lawyers disputed the meaning, and linguists could dispute the meaning as well. You can say, well, it's ambiguous. It certainly could mean give it to him. It certainly could mean shoot him. The problem was that Bentley said, "I never said it." When the police officer said, "Yes, he did, we heard him." But worse, the man who shot said, "I never heard it." So that's an interesting legal question. If I say something and you don't hear it, in terms of speech acts, have I committed the speech act or not? In other words, have I incited you to shoot if you haven't heard my incitement? Interesting question. But the court didn't consider that because they assumed both of them were lying. So what we had here was he incited him, but did he know? Did he know he had a gun? Bentley said, "No, I didn't know." But the judge, who was anxious that this case finished quickly, anxious that this man was convicted and hanged because there was a worry that more and more armed robberies were being committed in London and they wanted more protection for the police. The crucial sentence was sentence 23. I did not know he was going to use the gun. The judge said to the jury, look, he says, I did not know he was going to use the gun. And as you all know, in English, the means this is something we know about. I didn't know he was going to use the gun. This is the gun that I knew he had got. So in his own statement, he convicts himself because he didn't know he was going to use the gun, but he did know he got the gun. That's what the judge said. However, if we take Bentley's claim that this was in part question and answer, and if the police officer asked him after the event, did you know he was going to use the gun? And he says no. The police officer writes that down as, I did not know he was going to use the gun. So it's not the gun I knew he had at the time, it's the gun the police officer has referred to after the gun has been used. And one of the things we can do is find evidence here that this text was indeed produced by question and answer. And one of the pieces of evidence that I used here was from an article written by Michael Halliday. Michael Halliday has the concept of marked and unmarked. And one of the things he says is that if you've got a binary choice as between positive and negative, I did know, I didn't know, he says the negative is the marked choice. And borrowing, interestingly, from information theory, what he said was you get the most information when there's roughly a 10-to-1 chance of something happening. So you would expect the marked choice to occur about 10% of the time. And he worked with the co-build corpus, and he demonstrated that indeed negatives occurred 10% of the time when you were looking at verb phrases, so that negatives are the marked choice. What we discover in this text is that there are many more negatives than you would expect. But when you start to look at the negatives, it seems fairly clear that many of these negatives are negative responses to questions which have been turned into statements. And I just want to try and evidence that for you. If we look at sentence 17, up to then, Chris had not said anything. Now, if one wants to claim that this is a monologue, it's an incoherent monologue. Why should he say, up to then, Chris had not said anything? If it was coherent, it would be, he hadn't said anything, but he then did say something. Why? What's the reason for asserting the negative unless you want to do something with it? There's nothing before. It's not that he said something and up to then he hadn't said anything, or up to then he hadn't said anything, he did say something. It's totally incoherent because we have Chris then climbed up onto the roof and I followed. We both got out onto the flat roof. In the middle is, up to then Chris had not said anything. Now there are a series of these where the explanation appears to be that the policeman asked him a question, he said no, and this came out as a negative. And I'm pretty sure that for the same reason, sentence 23, which was the sentence that executed him, I did not know he was going to use the gun, is the same because it is also incoherent. You have, we were waiting there for about 10 minutes. I did not know he was going to use the gun. A plainclothesman. So he doesn't use the gun. It's not that he shot the gun, I didn't know he was going to use it. I didn't know he was going to use it, but he did use it. It's just a sentence embedded without context. But, as I say, the judge said to the jury, just look at this sentence. I did not know he was going to use the gun. What gun? The gun that I knew he had. The judge, of course, ignored sentence 41. I did not have a gun and I did not know Chris had one until he shot. The judge ignored that, but drew attention to the I did not know he was going to use the gun. Now, I could go on, but I think I've said enough to demonstrate two things. Firstly, this is definitely a co-production. There are definitely lots of police language embedded in here. And secondly, that because of that, the judge was able to draw a erroneous temporal conclusion. He was assuming that I did not know was contemporaneous, whereas in fact it was, and after the event, after he'd shot, of course he knew he had the gun, even though he didn't know he was going to use it, but it's not, I didn't know he was going to use the gun that he would then use. It's I did not know afterwards that the gun that he did use, he had actually got. This case we went to court with, and it was so important that the Chief Justice at the time in England was the chairman of the appeal group. There were three justices. He insisted on chairing it because the judge who had given the decision in the first case was also the chief judge. So he was the chief justice, and if they were going to criticise a chief justice, it had to be the current chief justice who actually did it. And they produced a report which seriously criticised the way in which the chief justice had run the case. And they criticised his summing up, because in the English system, unlike the American system, the judge produces a summary of the evidence for the jury. In the American system, it's just the two lawyers who produce a summary. In Britain, the two lawyers, the prosecution and the defence, produce a summary, but then the judge also produces a summary which is supposed to be unbiased. He's supposed to say, these are the facts. The prosecution have put their persuasion on it, the defence have put their persuasion on it. I will now tell you exactly what the facts are. In fact, the Chief Justice produced a prosecution summing up, basically urging the jury to convict, which was not his role at all. But as I say, we went to court with the linguistic evidence. There was other evidence, but the main arguments in this case were linguistic, and the arguments were about, my arguments were about the statement, other arguments were about the language of the summing up of the justice, the Chief Justice. And as I say, after 45 years, the conviction was quashed. Of course, it didn't help the man. I mean, this is one of the reasons for not having capital punishment, because if you discover a mistake, you can rectify it. You may have read last week, somebody in the States was released after 30 years on death row because they discovered that the evidence was flawed. So at least the case improved the nature of British justice, even if it didn't help this particular this particular suspect and convicted man. Okay, I want to change tack now. I'm not going to look, at least at this moment, at the next text. But I want to move on to my second topic, which is interpreting legal texts. And as I think I mentioned at least once in the last 2 days, there's an interesting overlap between linguists and lawyers, because both of us have training in the interpretation of text. It's a different kind of training, but we both have training in the interpretation of text. Now, many of you, like me, may have come through a training which involved partly literature and partly language. And although I've not seen it expressed this way, the judges are often faced with the kind of problem that those who read literature are faced with. It's something that is often called the interpretation fallacy, or the intentionalist fallacy. If you're reading a literary text, do you really want to know what the author intended? Or do you just want to know what the text means? Now, people will always say to you, or at least literary theorists will say to you, you can never access the intention of the author. So all you can do is say, this is a legitimate interpretation of the text. Now, not simply for years, but for centuries, lawyers have been worried about, or judges have been worried about, what is their function? How far is it to decide what the law was intended to mean? And how far is it to say, well, all we are interested in is what the text means, not what the writer of the text meant? Now, if you talk to the people who make the laws, the people in the legislature, the deputados and the members of parliament, they will want you to say, well, of course, this is our intention, and the law is the embodiment of our intention. But lawyers still argue about this. At the moment, the textualists or the literalists are in the majority in the American Supreme Court. But there are always ambiguities, and often you find, as my academic lawyer friend Larry Solon says, often you find the judges twisting and turning when they feel that a literal interpretation won't give them the right interpretation, or won't give them the decision that they want, that they work to make sure that they can justify what they think was the original intention. Now, I thought it would be useful for us to look at a few cases and see the kinds of problems that judges face and what kinds of solutions do they come up with. Now, as I say here, in the UK at least, about 40% of the cases are concerned with the interpretation of a word or a phrase or phrases. So, let's have a look at a case from the States here. Mr. Staples was convicted of violating the National Firearms Act because he failed to register a rifle he owned and was sentenced to 5 years probation and a $5,000 fine. The rifle was an AR-15 assault rifle that had been modified so that it could fire multiple shots with a single pull of the trigger. The Act requires the registration of automatic weapons, and the indictment against him was that he knowingly possessed a firearm not registered to him. In the National Firearms Act, firearm is a term of art. This is a legal expression for a word which has been defined. Remember, I was talking yesterday and the day before about the fact that, at least in English law, there are ordinary language and there are terms of art, and there's nothing in between. So ordinary language is what everybody understands, ordinary meanings. Terms of art are ones which are defined. So a firearm had a definition, and the definition includes automatic weapons but not single-shot rifles. So if it was a single-shot rifle, he didn't need to register it. If it was a multiple-shot rifle, he did need to register it. And so he's accused of knowingly possessing a rifle which he should have registered. So it seems quite clear. He had one, he knew he had it, and he didn't register it. However, he admitted that he had the rifle, but he said he didn't know it had been modified to be used as an automatic weapon. So the question is, as you can see, what does knowingly grammatically link to? Does it only link to possessed, because he knew he possessed it, or does it link to knowing that it was a firearm? And that was the debate for the lawyers. What does knowingly link to? He admitted to knowing that he had it. He didn't admit to knowing that it was a firearm. He said he thought it was a rifle. He didn't know it was a firearm. Where would you go on this? If you were the judge, what would you do with this?
I don't think you could prove it. I mean, 100% you can't say what happened. And if in the American system, if there's a doubt, he's not guilty.
Yeah. So, question is, do you say you can't demonstrate that he knew it? Let me take a step sideways. What about plagiarism? Where do you stand on plagiarism? Because you have the same question with plagiarism. Do you need intention to plagiarize or not? You find a student has got a whole section and you say you plagiarized. They say, oh, I didn't know that was plagiarism. I thought I was just using something that someone else had written. The law usually protects itself and says ignorance is no defense. It's your job to find out. So the fact you didn't know this was a rifle, and I'm not sure, I believe it because the first time you used it you would discover that it was multiple shot. And so that was the decision the justices came to. They said that ignorance is no defense. What you had was a firearm. You knew you had it, and therefore you can't claim to have been wrongly convicted. So, That one was fairly simple, as it often is when there are laws that tell you how to do interpretation. The second one is linguistically quite interesting, because unusually it actually involved linguists. The US Supreme Court has established an interesting procedure, which is about 6 months in advance, they announce a series of cases that they will actually discuss. So they announce 6 months in advance, and they publish the cases and the data about the cases. And there has grown up in the States a tradition that academics can't approach the lawyers, the judges directly, but what they can do, they can access the cases, they can write an academic article and publish it, and then send the article to the Supreme Court. And very often now, those articles which are seen to be relevant are read by the justices and often used and sometimes quoted in the judgments. Now this case here is one where 3 linguists and a lawyer worked together on it. They wrote the article, they sent the article to the Supreme Court, and in their judgment the justices referred to the article and used some of the examples from the article. So this is one where linguists were allowed to have a direct input into the decision. The case itself is quite strange, I think. The facts are as follows. A Mr. Granderson pleaded guilty to a charge of destroying mail, for which the maximum custodial sentence, that's if you go to prison, was 6 months, although there was the option of a fine and probation. The judge decided to give Mr. Granderson probation, and he put him on probation for 5 years. That is 60 months. So for 60 months, the sentence was suspended, but if he convicted, then if he did another crime, then it would be reviewed. Subsequently, Mr. Granderson violated his probation because he was caught in possession of cocaine. In such cases, the law instructs the court to revoke the sentence of probation and sentence the defendant to not less than 1/3 of the original sentence. So, he was on 60 months probation, they cancel that and start again, and they sentence him to not less than 1/3 of the original sentence. The question is, what does the original sentence refer to? Does it refer to 60 months probation, or does it refer to the alternative, 6 months in jail? Here you see the person who drafted this statute didn't get it sufficiently clear. So what you now have to decide is, what do we do? Are we interested in what the law intended, or are we interested in what it says? This presented the court with a problem, because if it took the original sentence to refer to probation, imposing a sentence of not less than 1/3, 20 months probation, could in fact reduce the penalty because he'd not yet served 40 months. So that seemed an unfortunate ruling, that by committing a crime you reduced your sentence for the previous crime. In the end, they decided to sentence him to 20 months in jail. That is a prison sentence which, rather being not less than 1/3, was more than 3 times greater than the original maximum prison sentence. Okay, as linguists, just think about this. As linguists, what can you say to the court? What does one do with this? This is a question of interpreting language, which we ought to be quite good at.
Was destroying mail. The second one was possession of cocaine. Are they equal in the system?
The question is, if he'd been first convicted of cocaine, would it have been a different basis for the sentence? And I'm sure it would have been. So it looks as if he's benefiting here in various ways from committing one crime before he committed the second crime, which is why the judges were in difficulty and why, obviously he came out with a bigger sentence. But when he appealed the sentence, then the Supreme Court had to decide what to do with this. What the linguist said to them was, independent of the time that you decide, that is a judicial decision, what the original judge has done is to misinterpret the language. And they used the metaphor of a visual illusion. Some of you may have seen recently on the internet a picture of a cat and some stairs. Did you see that? Yes? And the question is the cat going up the stairs or is the cat going down the stairs? And you look at it and some of the time you think, yes, it's going up the stairs. And some of the time you look at it and you think, it's going down the stairs. But visual illusions, you can only see one at a time. You can either see it going up the stairs, or you can see it going down the stairs, but you can't see both. And there's a whole series of visual illusions where you can switch. There are two possible interpretations, but at any one viewing, there's only one interpretation. Now, what the linguist said to the Supreme Court is, you have to decide what sentence means. And you can't have the same word having two different meanings simultaneously. And they said, what the original judge has done is to take sentence to mean probation in terms of the sentence to mean imprisonment in terms of the kind of sentence, but at the same time has used it in terms of probation to decide the amount of time. So that you either have to decide if sentence is probation, and then you say not less than a third of the probation time, or you say the sentence is jail, and you say not less than 2 months in jail. You can't take sentence to say at one time I want to take it meaning probation, and on the other I want to take it as meaning jail. So you have to have, and the Supreme Court judges thought that was wonderfully clear, and that was the decision that they came to. They were still unhappy with it being only a third of the time, but that was the statute they were forced to work with. And so, as he'd been in prison already longer than he needed to be, then he was released immediately after the Supreme Court decision. But as I say, that was an interesting case, and I think it's an interesting way to do law, to actually have it so public that everybody knows in advance and everybody can contribute an opinion that may help in the final decision. Let's have a look at an English case from the 19th century. This is about an aging couple who had no children. Before going to the Far East, Dr. Rowland and his wife made identical wills. Both left their property to the other unless death was preceding, unless the other's death was preceding or coinciding, in which case, as they had no children, other relatives were to benefit. So, if the husband died first, the money went to the wife. If the wife died first, the money went to the husband. If they died simultaneously, his money went to his nephew, her money went to her niece. That's what the will said, or at least that's what they thought the will said. And when you read cases like this, you realise you need to be very careful to make sure if you leave a will, the will actually achieves what you want it to achieve. Both were on a ship which disappeared without trace. So they're both dead. So the question is, who gets the money? Instead of being willing to divide the inheritance with the other potential heirs, the beneficiary of the wife's will claimed the whole estate, on the grounds that if their deaths were not coinciding, and who could prove that they were, the wife, being the younger, would be deemed by the law of property to have survived him. So the wife's niece claims all the money, instead of saying we'll divide it in half and my uncle's nephew can have some and I'll have the rest. This divided the judges, because lawyers had already thought about what to do in situations like this. And apparently, if you and your partner die simultaneously, the law arbitrarily decides that the older dies first in order to solve any problems. So if you want to make sure that all your money goes to your relatives, you have to have an older partner, and then the law will decide the older partner has died first and everything will go to your relatives. So that is the legal decision. That is the basis on which the niece claimed all the money. Said, we can't prove that they died simultaneously. Therefore, all my uncle's money goes to my aunt, and all my aunt's money goes to me. Now, as I say, in theory, judges say you can't tell intention, and therefore all you can do is interpret the text. And the judges argued long and hard, because two of the three judges argued that obviously the intention of the will was that in a situation like this, the money would be divided equally between the nephew and the niece. And that was the intention of the will. But unfortunately, the literal interpretation of the will doesn't allow that. The literal interpretation of the will has to have the overriding legal interpretation, which is the wife was younger, therefore she must be arbitrarily assumed to have died second. And so the niece got all the money, even though everybody except the niece felt it was very unfair. So that simultaneously, as the couple wrote it, couldn't mean legally simultaneously. It couldn't mean simultaneously because there was a more important legal statute which said nobody can die simultaneously. And if there's no evidence, then the older is judged to have died first.
How can you write that so that you don't get that result? I think you could.
Yep. I think what one would have to say would be, if neither of us survives, wouldn't you? If neither of us survives any type of accident, yeah, if there is no surviving, if there is no one surviving for a particular amount of time, this actually happened to me very sadly with my parents, because my father died and my mother died 2 weeks later. And this complicated things because we had to go through the transference of everything he owned to her and then the transference of everything she owned to me. And each time you had to pay a tax, yes. So that on my father's money we had to pay tax twice because it had to go through my mother to come to me. So, I mean, you know, I suppose in wills what one needs is some kind of time to say, if X survives me by, doesn't survive me by a certain amount of time, then the money will go to a third party. It's always possible, isn't it? But you have to think about it. I want to end this little bit with what I think, yeah?
Excuse me, when can disappearance be used as a proof of death?
I don't know what the legal definition of disappearance is, yeah, because, I mean, particularly in Latin America, people disappear for long amounts of time, don't they?
What happens that the ship disappeared without trace?
Yes, yeah.
I guarantee that they both died, but
Well,
the only problem is whether one died before or they
yes,
died at the same
yeah,
time.
yeah.
That's not the only problem.
No, it's not, no. Yes, just like the Malaysian airplane which has disappeared. Yeah. Yes. However, the lawyers didn't worry about that. I don't know how long after the disappearance. I mean, the ship was obviously reported missing. The people were claiming insurance on the ship. But this last case, I think, is a nice one to stop this little part with. Again, it's from 19th century, but this time from the States. A 19th century US statute made it a crime in any manner whatsoever to prepay the transportation of an alien to perform labour or service of any kind in the United States. So, if you wanted to work in the States, you had to have enough money to get yourself there. Your future employer couldn't pay for you to come and work for him or her. That's what the law said. I don't know why they were doing it that, but that's what the law said. However, a church was convicted of violating this statute because it prepaid the transportation of its rector from England. So, what are the judges going to do when the law says you can't prepay? The church prepays. Now, obviously, you definitely want religious men to come to your country because they will contribute to society. Is there any way in which the judges can manage to get round the law that has been created for them? I suppose you could say that priests and Padres don't actually work, so they don't do any labour. That would be, you could try and say, yes. Let's see what they did. Is a rector a labourer? Writing for the unanimous court, Justice Brewer first noted that the act of the church is within the letter of this section. So in other words, we have to apply this law to them. However, it's a familiar rule that a thing may be within the letter of the statute and yet not within the statute because it's not within its spirit. So, okay, what we're doing here is he's talking about intention rather than what the statute means, nor within the intention of its makers. So, although they're not supposed to do this, the judges are now talking about intention. And he then says, no one reading such a title would suppose that Congress had it in its mind any purpose of staying the coming into this country of ministers of the gospel, or indeed any class whose toil is that of the brain. So they're distinguishing between labouring and thinking, and so all of us would have been okay. You see, we could have had our passage paid because, at least in theory, we are working hard with our brain. We're going to break in a moment, but before we do, I want to give you a task to think about during the break, okay? And the task is, how can you define buttocks? I can't remember what it is in Spanish. In Portuguese it's nádega, so it's a word something like that. Let me see. Nalgas, okay? Right, what I want is a definition of nalgas. This is because the state of Florida, in drafting a law attempting to reduce the amount of exposed flesh in establishments featuring nearly nude dancers, had to define buttocks because the law said they had to be covered. Okay? So what you need is a definition to give to policemen who have to go to these establishments to check that the dancers have their buttocks covered.
You can give that to teachers today because the pants, the girls.
Yes, I know, yes.
All the buttocks.
Yeah. So there's a you can do it in Spanish if you like. I mean, it's not an easy task. So that is what you have to do. You have to help the Florida court because they will need it in Spanish as well. I mean, Spanish is now almost the major language, isn't it, in Florida? You need a definition of nalgas in order for the police officers to be able to go with their tape measures and check that the women are decently clothed. Think about it. Let's take a break.